Hello and welcome everyone. This is the last talk in this term's Talking Animals Law and Philosophy series. I'm Raphael Fizel, the Executive Director of the Cambridge Centre for Animal Rights Law. Some of you may be attending one of our events here for the first time, so I'm just going to say a few words on the format, and I'm going to admit some more people who are in the waiting room in the meantime. We will have the opportunity to listen to a presentation that will last for about 45 minutes or so, and we'll then have another 40 minutes for Q&A and discussion. We will end the event at around 6:30 p.m. UK time. As always, everyone is warmly invited to participate in the discussion that will take place after the talk. In case you would like to make a comment or ask a question, I would invite you to use the raise hand function, which you will find under the reactions button or the participants button, depending on your Zoom version. In case you can't locate the raise hand button, which seems to be a common problem, feel free to use the chat function instead and to put your questions or comments in there. And I will then go through the different raised hands in chronological order, or indeed the chat comments, and allow you to ask your questions or make your comments directly to our speaker and to allow them to respond to your points. Now, all the microphones will be muted until then. Just to let you know also that we are again recording this talk in case you need to leave early and would like to watch the rest later. This will be uploaded to our website in the coming days. But let me now introduce our speaker. Today we have the pleasure of listening to Pablo Pérez Castelló, who is a visitor at the Cambridge Centre for Animal Rights Law. He's been a visitor here together with Eva Burnett-Kempers and Joshua Chowitt, from whom we've heard as well. They've all been here during Lent term doing research. Now, Pablo is a PhD in philosophy candidate at Royal Holloway University of London. Pablo's thesis tries to understand the role human language plays in producing anthropocentrism and the importance of animal language in relation to political agency and zoodemocracy. Pablo's research here at the Centre for Animal Rights Law explores how the Australian Constitution should change in light of the argument advanced by Sue Donaldson and Will Kymlicka that communities of wild animals should have a right to sovereignty. Now, today, he will be exploring some of these questions with us in his presentation entitled Legal Animalhood, the Constitutional Recognition of Wild Animals in Australia. Pablo, I'm going to hand over to you. Thanks a lot for being with us today.
Okay, thank you, Raphael, very much for your introduction. Let me share my screen, perhaps. Is that working? I hope it is.
Yes.
Fantastic. Thank you, Raphael. Well, the first thing I wanted to do is, apart from thanking you, Raphael, and Son, for all your help these last months, I also wanted to thank you for all the work you've done over the last couple of years. It's been excellent, so I just wanted to mention that. So my talk today is going to be on legal animalhood, the constitutional recognition of wild animals in Australia. So the first thing I wanted to mention perhaps is that a little bit about my background and the motivations to work on this, because it's going to help to situate the paper, and I think it will help to understand better why I'm going to propose and what I'm going to propose and the arguments I'm going to put forward. So as Raphael was mentioning, I come from continental philosophy, animal studies, and also I'm very influenced by intersectional scholarship, ecofeminism, critical race theory, critical disability studies, and other areas. So the thing is that my work is mainly theoretical, but I have always been very interested in how theory constitutes our practices. This is something that I've always been concerned with, how, if you like, even anthropocentrism that Raphael was saying is central in my work. So how this idea that human dominion, we humans dominate animals, and this idea that the human is at the center, how this influences our practices and in some ways it determines them. So when I was over the summer of 2020, I was working on the application to working at the center as a visitor. And I wanted to find something that related to theory, practice, and somehow as well strategy. So I was trying to find a way to advance arguments that will help us to get animal rights done, as it were. And at the same time, more or less, I had been working on an article in conservation with a colleague. And so I started thinking, well, it might be the case that wild animals could be a good target to get some fundamental legal rights for animals. Perhaps wild animals would be a good place to start, as it were. And also, the work of Sue Donaldson and Will Kimlicka, their book, especially Zoopolis, figures importantly in my own work. It has influenced my thinking a lot. And especially this idea, I've moved a little bit from sovereignty, it's more the idea of self-determination. So the idea that animals have their own modes of social organization, that they are agents, they make decisions. That kind of idea is very present in their work. So then with this in mind, I was trying to think, okay, how can we turn this idea that animals have an interest in living self-determined lives into something more concrete, something that gets us closer to get animal rights done, as it were. So I ended up coming up with this question, there it goes, which is what I'm going to really focus on today. So how should the Constitution of Australia change if it recognized the right to self-determination of some wild animals? And the reason I chose to focus on this question is that getting animal rights done is important, as I have said, and also, and I say this in my article, sometimes change does not happen because we cannot even imagine what legislative changes could be made and how they could be enforced. So that's a little bit what is driving me to ask this question and to explore this matter. So something that I wanted to say very briefly about the approach I'm taking is that, well, I'm saying, and I've said this several times already, that I'm trying to do something strategic, yet I'm asking a question about recognizing the right to self-determination of wild animals in a constitution. So some of you might be thinking, well, isn't that a utopic question rather than a realistic one? And Aleister Cochrane, he says in his book, Sentientist Politics, and I think it's going to help us, this quote to situate what I'm doing, that this book is primarily concerned with what justice demands, as opposed to what might be achievable here and now. So my approach, like Cochrane's and Donaldson and Kimlicka, is driven by what justice demands. But I am also considering seriously strategic matters and how we could concretely get some fundamental legal rights for animals. So, for example, a constant concern for me these last months that I have been researching about this question has been with whether humans would say yes in a referendum that asked about whether some wild animals should have certain fundamental legal rights. So in Australia, if the constitution had to change with the legal status that I am going to propose today, it would have to be voted. All constitutional changes need to be voted in Australia. In any case, the point is that methodologically speaking, I have not based my thinking only on theoretical matters. I have grounded a lot of my proposals on the Australian context and what might be feasible within that context. So a lot of what I will say and propose today is driven by justice, but is also constrained by reality and the strategic matters. Okay. So now, very briefly, I want to say about the structure of the talk. So the first thing I will kind of show is why animals have an interest in leading self-determined lives. Then the current legal status of wild animals in Australia, very briefly, and then my proposal of legal animalhood, legal status for wild animals. So then let's get to it. First, the interests. So the idea is that with these 4 cases, what I'm going to solve, one case with cows, rats, eels, groupers, and herds of horses, is sort of different dimensions of animal agency and different dimensions of why animals have an interest in living self-determined lives. The first one that I want to focus on is the case of cows that Charlotte Blattner, Sue Donaldson, and Brian Wilcox, they wrote or they published this article in 2020, Animal Agency in Community, a Political Multi-Species Ethnography of Vine Sanctuary. So what, just to say a little bit about Vine Sanctuary, about the space in Vine Sanctuary, which is going to help to kind of explain why cows are agents. So Vine Sanctuary is divided in two parts mainly, the upper hill and the fenced area. And the fenced area in the article, Charlotte, Platna, Donaldson, and Wilcox, they call it the commons. The idea is that the cows in that sanctuary, they are all rescued cows from factory farms. And there are some rewilded cows in the upper hill that they really operate like a rewilded herd, does it well. And then there is some cows that live always in the fenced area because they just want to do that. They choose to live in the fenced area. And then there are some cows that live in between. So one day they might be in the upper hill, another day in the fenced area, or even in the same day they might move up and down, right? So the idea is that there is a gate that separates the fenced area from the upper hill. And what is interesting is that the gate, Donaldson, Blatchner, and Wilcox say, acts as a choice point. And I want to really look at this case because it's going to illustrate really well, I think, that animals are agents. So the idea is that, well, the case that I want to look at is the case of one cow in particular, that she was ill, one of these cows, and then the human residents thought, well, we should really bring this cow within the fenced area because it is safer for the cow. So that's what they did. They took the cow within that space, and she really didn't want to be in the fenced area, so she went to the gate. She stood there with her body, and they started mooing insistently and constantly. So the idea is that the cow was really saying to the human residents, I do not want to be in this area, I want to be in the upper hill with the rest of the cows. So what I want to ponder and reflect on briefly is, what does that entail conceptually speaking? What does that cow need to do or be able to do in order to communicate that to humans? So the first thing that, and perhaps the most important thing that we need to pay attention to, is that the cow needs to be able to identify that gate as some sort of entry-exit point. It needs to signify entry and the exit, in contrast to any other part in the fence. So the cow does not go to a random place in the fence, it goes to the gate. She goes to the gate. So the idea is that there needs to be some form of conceptual understanding, not like a human understanding of gate, but some form of understanding that that gate signifies exit entry. And not only that, the cow also knows that if she goes there and she communicates with her body that she wants to go out, and that by mooing, she's communicating this, that the human residents will open the gate. And this is not exclusive to this cow. All the cows act like that in Vine Sanctuary. So I think the point of this case is that we can see a form of agency. We can see why cows do make decisions and why they have an interest in making these kind of decisions in leading a life that really is, they lead a self-determined life, as it were. So then, the case of rats, that they decide with whom they bond with. This case, I'm not going to explain it in so much detail. It's from an article by Weiss et al. In 2018 in Animal Cognition. The only thing that I want to mention from this case is that rats form bonds with specific partners. So again, the question is, what does that entail? The idea is that for a rat to have a preference in relation to bonding with a specific partner, she must be able to recognize that different individual rats are in some respects different, and identify stable features of that individual that characterizes her. In other words, rats must be able to recognize other rats as individuals in order to form relationships and bonds with specific partners. And the idea is that if one rat says she wants to be with this specific rat and the other rat agree, they can form long-term relationships. So the point is, and I want to make clear that my argument when I say this about cows and about rats is not that rats recognize individuals like humans do exactly in the same way, but rather that rats have some form of awareness that allows them to decide with whom they want to establish relationships. The point is that rats have an interest in making such decisions in their own terms, and in those decisions being respected. Another case of eland and groupers cooperation. So eland groupers, even though they are from different species, Victoria Braithwaite in her book Do Fish Feel Pain explains about this, they communicate with each other with each other, and they hunt together. They cooperate and they can hunt together. So again, the question that I want to ponder is, what do they communicate to each other? And what does that communication require conceptually and in relation to animal agency? So first, obviously, what they communicate is that they are going to go hunting. And this requires some form of awareness of when they are going hunting and where they are going to hunt. And also to have some form of understanding of the other's actions. So the thing is that just think about what all this process entails while they hunt. So they need to have some form of concept of, for example, rocks, shapes, the other, if we look at it from the eel's point of view, so they need to have some idea of what the group is doing conceptually so that the action can be coordinated. So the point is that they are making decisions constantly while they hunt. And these decisions require that they are in the world in a conceptual manner of some form. And then the last one, what we've seen so far is, in a way, instances of individual agency, even though one is more individualist, if you like, the other one about the relationship, and the last one about coordination. This one is going to be about the collective interests of a herd of horses in self-determination. So horses, they live in social groups, they form strong social bonds, and they relate to each other in an affiliative manner and recognize each other as individuals. Horses also play with each other. So what all this is kind of indicating, and Ansel and Kimlicka get into this kind of case in depth in Zoopolis, is that they have their own internal dynamics in the herd. As a herd, they have their own forms of social organization. And what this means is that social animals, such as horses, have collective interests in autonomy as a means of community flourishing, and in preserving their own modes of social organization and self-regulation on their territory. So the thing is that when animals are deprived from developing their own modes of social organization, establish social bonds in an affiliative manner, and live as the kind of beings and communities they are, these deprivations should be treated, as Martha Nussbaum says, as causing a kind of premature death, the death of a form of flourishing that has been judged to be worthy of respect and wonder. The point is that animals have an interest in leading self-determined lives as individuals and communities, and these interests need to be protected and respected. So now the question is, how does Australian law protect these interests? Very briefly, I'm not going to get into much detail here, but what you need to bear in mind is that wild animals, in contrast to domesticated animals, are not property. They don't have property status per se. They have a qualified property status. They are nobody's thing, res nullius. And what this means that they have a qualified property status is that they can be objects of property rights when they are killed by landowners in their lands. So then when this happens, the animal becomes an object of property rights. And also when they are captured and domesticated. For example, a lot of conservation programs, they do that. And when they capture animals to then take them into zoos, in this kind of case, then animals become property, or they become objects of property rights, to be more accurate. And then other considerations about their status. So in Australia, a big thing as well about the legal status of wild animals is that they have this big divide between invasive introduced species and native endangered species, which acts a little bit like racial discourse. It's like a racial grammar. I wrote an article on this with a friend of mine. And the idea is that those species that are native endangered, they are kind of sanctified. And what that means is that whoever and whatever puts them in danger, they just kill them all. Obviously not humans, but all the other animals that might put them in danger, they just kill them literally. And as they say in some policy, they eradicate them. And then the jurisdiction as well is quite important, because Australia is a federal country. So depending on the state, the legislation might be significantly different. So because now we've seen more or less half of what I'm going to say, just as a kind of summary of what we have seen. So the idea is that animals have an interest in living self-determined lives. And the Australian current law does not protect it sufficiently obviously. So they are killed in for conservation programs. They can be objects of property rights. So the idea is that we need to have a different legal status, or at least their legal status should change. Now, what I want to kind of pause a little bit here and say something that I believe will situate a little bit what I've done so far in relation to something Sue Donaldson said in a recent interview in the Animal Turn. So Sue Donaldson said there that what we should do, and by we I mean animal rights people, is to focus first and sort of ground ourselves in animals' experiences and in who animals are. And the idea is that by being grounded on that, then we should sort of translate into political terms who animals are, kind of and translate that into more systemic terms, more legal terms. So what I've tried to do in this kind of first half of the presentation is to ground ourselves there in animals' experiences, in who they are. And now in the second half, I will focus on trying to see how we could respond and how we could have a different legal status for animals, one that protects better their interests. And that's the idea of legal animalhood. Okay. And this because it's going to be, I'm going to spend more time on this part of the presentation. So I'm going to go back to this slide so that we don't get lost, because there is perhaps quite a bit of content. So in the first thing that I'm going to try to answer is this question of why legal animalhood and non-legal personhood. I'm going to propose that animals should have a new legal status, or at least some wild animals should have the legal status of legal animalhood. So the question is, why don't we extend legal personhood? Why don't we include animals in that category that we already have? I'm kind of trying to answer that question. And then the content of the status, which will be divided into parts: fundamental legal rights. So that is what protections would be conferred to wild animals under this status I'm proposing, and the definitional part. So to whom would the status apply and where? And by where I mean that one of the fundamental rights that animals, I will say, should have is wild animals, is a right to place. So the question is where? Where should they have a right to place? In all Australia, in only some territories? So I'm going to also look at that. So the first question, is legal personhood more than a legal category? I'm going to base basically my answer on Melissa Decca's book. It was published this year in 2021, Animals as Legal Beings, Contesting Anthropocentric Legal Orders. Melissa Decca gave a talk on this book here at the center, so you can check it on the website if you are interested in it. And what Decca argues in that book is that while hypothetically, and not only hypothetically, in fact, in reality, legal personhood can change in almost any way. In fact, corporations and entities such as idols and rivers, they are persons as well. And Melissa Decca, as a lawyer, obviously she's more than aware that that's the case. However, she sort of says, well, it is very unlikely that this will happen, although it's not impossible, because the category of legal personhood was constructed in the image of the paradigmatic human person. That is, a being who is rational, an independent man, white and able-bodied. Just think about who have been legal persons with full rights under the law historically. Women and Black people, for example, were not full persons under the law until way into the 20th century. In Animals as Legal Beings, Decca also explains that dehumanization has played and plays a very important role in losing personhood. She says that dehumanization has been and is, quote, a popular strategy to legitimate the stripping away of rights from human beings. In many instances of war and ethnic conflict, it is through dehumanization that personhood is lost. In this respect, consider also how people with cognitive disabilities and some psychiatric patients can be stripped away from fundamental rights now, today, such as the right to liberty. The idea is that those beings who deviate from the paradigmatic legal person too much can lose fundamental rights that a legal person is meant to have. So the point is that animal personhood is an oxymoron in anthropocentric legal systems, which is not to say, and I really want to insist on this, that legal personhood theoretically and in actual fact cannot include animals. Legal personhood can include animals. Decca's point, and I am endorsing her argument, is that it is more unlikely that legal personhood will include animals than creating a new category, because legal personhood is intimately bound with the idea of the paradigmatic human. So perhaps to illustrate this point a little bit more, in a more illustrative manner, in a way, when a judge hears Stephen Wise in court saying that the great apes or elephants have practical autonomy and should be granted personhood, and the arguments that Stephen Wise puts forward are brilliant, judges subconsciously hear a dissonance. Personhood and animals do not go together. That's what is going on in their heads, right? Because of this idea that personhood is so bound to the human. And now, just this other case, let's imagine that a judge or legislator, especially a legislator, because what I'm proposing is a new legal category for wild animals, so this would need to be passed through legislative changes and so on. So anyways, let's say, but a legislator heard that animals are not objects of property rights like chairs are. Probably legislators and judges as well, they would probably say, certainly, animals are not things like chairs. And in fact, some judges have already said that in some case law. However, if one responded, well, then animals should be legal persons, sorry. They should be granted the status of legal personhood. A judge or legislator might be like, wait. One thing is to say that animals are not objects of property rights like chairs, and another altogether is to say that they are legal persons. Now, think about the following as well. Let's say that we kind of have the same case scenario, but our response as animal rights people is, well, if animals are not like chairs, then animals should be legal animals. We should create legal animalhood to distinguish animals from objects like chairs. It doesn't seem crazy to think that legislators and humans more generally, because this would need to be voted on a referendum in the case of Australia, would find that proposal more reasonable than granting animals legal personhood. I cannot say more about this now, but I hope you can see where I'm coming from and why I am proposing the category of legal animalhood. In any case, I'm happy to chat further about this if people have questions in the Q&A, okay? So we've seen now the why legal animalhood part. Now we will go to the actual content of the status. First, the fundamental rights. And they will be granted mainly three rights that are really, they all flow from the right to internal self-determination and place. I will not be able to kind of weave and explain very carefully why they flow from that one, or why they follow from that one rather than flow. But yes, these rights would be a right to self-determination, a right to immunity from being objects of property rights, and a right to political representation. So the first thing I'm going to do is kind of read what the actual formulation, as I have it at the moment in the article, and then I will sort of zoom into different aspects of the formulation that I'm going to read just now. So individual wild animals and communities of wild animals have a fundamental right to political representation, immunity from being objects of property rights, and to place and self-determination with respect to developing their own modes of social organization, living as the kind of individuals and communities they are, the protection of their ecosystems from human-induced activities, and then a kind of clause B, which would read like this: human interference shall be restricted by the previous clauses, which impose duties to do no harm either directly or indirectly upon wild animals. Now, the first thing that I want to say quite briefly about the issue of political representation is that animals have interests that need of protection, and that insofar as humans decide policies that have an impact on animals, they have an interest in having some form of political representation. In my article, I talk about this in more depth, but I don't have time now. What I would like to do, though, is to suggest that all to read the Danneker's books, The Open Society and Its Animals. I think she gets into more detail. She has a chapter on that, I believe. There. And now this kind of focusing on the right to self-determination, I want to look at these three sub-clauses, as it were. So I will not rehearse why wild animals should have a right to self-determination. We have already seen that earlier when I was explaining about that, the fact that they have an interest in self-determination. But I want to focus to mention and say that the protection of wild animals' interest in developing their own modes of social organization and living as the kind of individuals and communities they are, the first 2 points there, require that their ecosystems are protected from harmful human-induced activities, since obviously animals cannot live as the kind of beings they are if their habitats are harmed by humans. And what I want to say also about clause A3, the one about the protection of their ecosystems, is that I have not written harmful, because as soon as one writes such a clause, like unnecessary suffering, the question is, what is unnecessary suffering? Or what is harmful? So the point is that protecting animals' ecosystems does not mean and would not entail that we humans would not be able to use resources such as water. But I hope you can see why I'm not adding this bit of harmful, even though what I'm targeting is harmful human-induced activities. Okay, I hope it makes sense. And the other thing that I want to explain about the content of the right to self-determination, and in this, I kind of, for strategic reasons, I differ from Sudonalson and Wilkimlica, because their approach is much more ideal and seeks to grant animals a right to sovereignty, which is really what I call here external self-determination, which is autonomy with a right to secession. So what I argue in my article is that animals should be conferred a right to internal self-determination. That is, a right of animals to manage their own affairs in their own terms, but which it does not entail a right to secession. And the reason is that very few nation states are willing to put into question their territorial integrity, which is what a right to secession entails. In fact, Australia does not recognize the right to secession of indigenous peoples, but they do recognize the right to internal self-determination of indigenous peoples. I give more reasons in the article about why animals should be granted this kind of right to self-determination, but I don't have time to explain them here now. But if somebody is interested in it, again, ask in the Q&A, happy to discuss about it later. Then the right to immunity from being objects of property rights, I think is quite straightforward, so I'm not going to say much about it. The idea is that animals qualified or wild animals qualified property status is inconsistent with a right to self-determination. So if animals are granted a right to self-determination and they can develop their own modes of social organization, they can live as the kind of individuals freely in nature, do whatever they want, it would not make any sense that then they are owned by humans and humans can well control what they do. It's just an oxymoron, really, that these two things would coexist. And as a matter of justice, of course, I just think that no animal should be owned by humans anyways. But if someone, I think it's straightforward and quite clear why, but if someone has doubts, we can also discuss it. I also wanted to kind of give this fact now, because with these debates that there are sometimes in animal rights theory about whether the theory is just idealistic or realistic and so on, and perhaps people are thinking this is so far from something achievable or feasible. I read recently this survey from 2018, and I thought it was an interesting thing to know. So the survey was not a representative sample, but it still was in the state of Victoria in Australia, and they asked, do you know that the law classifies animals as property? And 58% of people didn't know, and 42% of people only, they said that yes, that they knew. But more interestingly, they also asked, do you think that animals should legally be classified as property? And 22% of people said no, and 36% of people said only some animals. So what we get is that 58% of people, almost 60, they said that they thought that animals should not be classified as property. Of course, this does not say that people would vote yes to if there was a referendum in the terms I am proposing. But the point is, we might not be as far as we tend to think from proposals of this kind, right? So that's more or less why I wanted to mention this poll. And then the definitional part. So to whom would this status apply, and where would they be granted a right to place? Again, like with the previous case, I'm going to first read what this definitional part would look like, and then sort of zoom into different aspects of it and sort of explain a bit better why I have formulated this as I have and why I am proposing this in these terms. So this part would read as follows: wild animals shall mean individual animals and communities of animals who live in wild animal territories and participate in wild ecosystems. Wild animal territories shall include, but are not restricted to, nature conservation areas, minimally used regions, and protected areas which shall not include territories provided for indigenous uses. Wild ecosystems shall refer to the biological communities of interacting terrestrial and aquatic beings that live in the above-mentioned areas. So first thing, and briefly, what point 1 and 2 say there entails that all animals living in those territories would be granted the status of legal animalhood. So initially, and for strategic reasons, that also means that only animals in the proposed territories would be conferred the status of legal animalhood. That does not mean, however, that other animals could not be granted the status in the future, or that more rights could be granted. We could add up more rights progressively. I also want to mention that I cannot see any reason why humans could eventually, so the point is that humans could also be part of this category of legal animalhood at some point. So Nora Taylor has this great quote in Beasts of Burden, where she says that we humans are animals, a fact so boringly commonplace that we forget it perpetually. So I only wanted to share with you this thought that it would be quite beautiful, I think, if perhaps one day we were all animals under the law, humans and animals. If we were all animals under the law, I thought that was an encouraging thought that I wanted to share with you, which of course, it doesn't mean that legal personhood should go away or anything of the sort. I do think that legal personhood has a place in relation to matters such as accountability, some duties that we humans have, but yes, I just wanted to mention that. And then, so about clause 1 and 3, that it differentiates between animal territories and wild ecosystems. So the idea of mentioning territories refers to the actual land and waters that animals would be granted a right to place over, as it were. And then the idea of having ecosystems there is that because wild animals' habitat would need to be protected from human-induced activities. So my idea was to explicitly generate the structural legal preconditions to force Parliament to legislate afterwards, once the status was passed, and protect wild animals from direct and indirect human-induced activities. So the idea is to sort of give more substance and content to ecosystems, and so that then later their habitats were properly protected, as it were. So that's more or less the idea of having that separation. And then we are going to look at what these regions are about. So nature conservation areas, minimally used regions, and protected areas that are the territories that would be granted to animals. Under current Australian law, there are already some regions that are classified in that way. So you see them here. It's this kind of purple, grayish, here in the legend you can see. So it will be all these regions. And I want to say that the reasons to choose these areas are the following ones. So first, they are already protected. So for example, all national parks are included in these areas, and they are mainly uninhabited by humans. Also, most of the land in these areas is unused by humans. We do almost nothing there. And then one could then ask, well, why don't we include other areas, such as, for instance, territorial waters in Australian seas? As you can see, there is no regions around in the Australian seas at all. And the reason is that it's purely strategic reasons. A quota of Australians fish for recreational purposes, for example. Also, if wild animals in places such as cities were granted the proposed rights, important infrastructural changes would need to be made. And more than half of the fish consumed in Australia today is not produced in aquaculture facilities. So the idea is that one of the things that I have thought these last months while I've been working in this article is how much people's daily lives would need to change if they voted yes in a referendum that asked about the proposed legal status. With this proposal, not much would change in the daily lives of people. People would continue to fish for recreational purposes if they wish so in unprotected areas, as it were. But some things, however, they would obviously need to change. So for instance, at the moment in these protected areas, so around these areas here, there are exemptions for mining. So mining happens in these protected areas. Mining would cease to happen if this status was passed. Also, no wild animals would be killed, in contrast to what happens now with most conservation programs and with hunting and other activities that harm animals. So importantly, many animals would, for the first time, have some fundamental legal rights that would be on equal footing with those of humans. This is an imperfect status, obviously. As I was saying all the time, it's a strategic one, or it attempts to be at least. But I mean, it would be huge if something like this was passed already with all its imperfections. And then I have here this little clause that says, but are not restricted to. And the idea of adding that up is that, say that there are some wild animals that move from this region to this other region for, I don't know, 1 kilometer, 2 kilometers, or for a few days or just a moment. The idea is that by adding that clause, animals would not lose the status immediately. However, if animals migrated and they just moved here and they started to live there permanently, or they move to cities, that this happens with some dingoes, for instance, they would lose the status. That's a consequence of my proposal, and I don't like it, but it's what it is and what it entails. And then also this other subclause that says that, as it is currently classified in Australia, all these regions, protected areas do include territories provided for indigenous uses. But I say that it shall not include territories provided for indigenous uses. And the reason is, as Clegg Kim says, that the majority should leave minorities alone until they clean up their own house. In other words, minorities' disadvantages earn them a place at the end of the reform queue. Having endured racism and colonialism, subjects deserve justice and reparation from their oppressors, but they do not deserve to dominate women, animals, and nature. I agree with everything Clegg Kim says in this quote. I do not think that any human in the world deserves to dominate women, animals, and nature. But minorities' disadvantages earn them a place at the end of the reform queue, hence the formulation of the status. And then another fact, with again this idea of, is this utopic, is this realistic? The University of Oxford and the United Nations Development Program, they elaborated recently the biggest survey ever done on climate change, which is called People's Climate Vote. This was published in 2021. And they asked 1.2 million people in 50 countries whether climate change is a global emergency. And 64% of people said that it is a global emergency. And interestingly, one climate policy emerged as the most popular globally, that of conservation of forests and land, which received 54% of public support. This is a very reliable survey. Obviously, again, this doesn't mean that the status I'm proposing, if it was going to be voted or anything, it would be passed. The only thing that I think this polls, like the one before, with the idea that perhaps many Australians think that some animals should not be classified as property, they shouldn't have property status. Here we also see that perhaps this idea of granting land, a right to place, to many wild animals in Australia, perhaps this is something that people would agree with, and perhaps we are not so far from this kind of proposal as it might seem at first sight. And then kind of to conclude and summarize a little bit what we have seen today. So what I hope I have shown is that wild animals have an interest in leading self-determined lives, and therefore they should have some fundamental legal rights, which I have said we should encapsulate in this category of legal animalhood. And the rights are a right to immunity from being objects of property rights. I have forgot to write here a right to political representation and a right to self-determination. And also something that I have been thinking about these last days while I was preparing this presentation is that a consequence that has emerged from focusing on something grounded on reality and on kind of strategy is that what has emerged is a sort of territories-based rights, which is relatively unusual, but it's what would happen. So wild animals in animal territories would be holders of rights. And then before closing, I want to read a quote from the article I have been working on these last months. And it says, sometimes change does not occur because we do not imagine what legislative changes could be made and how they could be enforced. I hope that this talk has shed some light in that direction, even though, of course, we need to do so much more. And now to end, I wanted to share with you an encouraging quote by Eva Meyer in When Animals Speak that I really like to recall quite often. So she says, we can begin again. We should begin again. So let's begin again. Thank you all for listening.